Welcome to today's webinar brought to you by OraSure Technologies. OraSure Technologies is a global leader in oral fluid substance abuse testing products. Their unique assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Oral fluid-based testing products provide a simplified collection process, faster results, cost savings with minimal risk of tampering, and dramatically reduced risk of adulteration. The Intercept Oral Fluid Drug Test is an FDA-cleared laboratory-based oral fluid testing system that enables accurate testing for drugs of abuse, including marijuana, cocaine, PCP, amphetamines, and opiate, as well as other drugs of abuse approved for use with the Intercept device. It was ranked as the #1 recognized brand name in oral fluid testing in a 2014 National Drug Testing Industry Survey. With a fast and easy-to-administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, the clinical setting screening programs, among others. Today's presentation is entitled New State Drug Testing Laws. It's time to get caught up, and will be presented by Bill Current. Bill Current is the president and founding partner of the Current Consulting Group and the publisher of the online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com. He is the author of 10 books on substance abuse-related issues, including the popular title, Why Drug Testing? CCG is a leading provider of drug testing policy writing services, working with companies to help them optimize their drug testing ROI. Bill is the former executive director of the American Council for Drug Education and vice president of consulting for Employee Information Services. It will now be our pleasure to hear from Bill Current.
Well, thank you, Jessica, and welcome to everybody who has logged into today's webinar. First, I'd like to acknowledge our sponsor today, OraSure Technologies. One of the things we do here at the Current Consulting Group is we have a webinar hosting business, and it has been our pleasure to work on a monthly basis with OraSure Technologies. They sponsor these monthly webinars, and they bring them to you free of charge on your end. And we really want to thank them and acknowledge their efforts to bring good information, solid information to the drug testing industry on a regular basis. The most important thing that we can do is just to stay up to date on the developing trends, the new laws that come into play, which we're going to talk about today, and the various things that people in the industry and employers are doing to try to establish, maintain drug-free workplaces, as well as deal with things like medical marijuana laws and recreational marijuana laws. And so it's important to stay up to date on these. And so our thanks go out to OraSure Technologies for sponsoring these monthly webinars. Also, Jessica mentioned that we do an annual survey of the drug testing industry, and 2015 will mark our 17th annual U.S. survey. We also do an international survey, which will be in its third year in 2015. It's been our pleasure to present the results of our U.S. survey every year that we've done the survey at the SAPA conference, the annual conference, which we will do again next year. And we have the pleasure of releasing the results and reporting on the results of our international survey at IFDAT's annual conference, which we've been invited to do again next year as well. If there's anybody on today's call who has an interest in participating in one of our surveys, either as a corporate sponsor or as a survey participant, just send me an email at bill@billcurrent.com, and we will be happy to put you on our list or to send more information to you. So today's topic, and we do this every December, we do a webinar to report on legislation that was passed at the state level in 2014. And there was a lot of activity this year. There was last year as well, an equal amount this year. These are states that passed different bills in 2014 that affect drug testing. Now, some of it's drug testing in the workplace, some of it's drug testing in other scenarios, criminal justice or welfare, food stamps, temporary assistance for needy family programs, things of that nature. These are the states that passed laws. As you can see, some states passed more than one law, And it kind of breaks down this way. There were states that passed drug testing specific types of laws that were specific to certain industries. There were, of course, the marijuana laws that are kind of in a class by themselves. We've got workers' comp listed here and controlled substances, and let me explain why. It's one thing, and it's a good thing, to look at a state's drug testing law when putting a program together in that state. But by itself, in and of itself, it's not enough. You've got to make sure that you're looking at other types of laws that can affect drug testing. And one significant area of law that affects drug testing is workers' compensation laws, as well as unemployment compensation laws. We track all of that through statedrugtestinglaws.com, so our subscribers get that information. But those laws change from time to time, and we're going to report on one of them here today. And then on the controlled substances side, the reason why we track this one is because some state drug testing laws and even some workers' comp laws at the state level, when discussing which drugs an employer can test for, as an example, they will simply defer to the state's list of controlled substances, or they may defer all the way to the U.S., the federal controlled substances list. And when they make changes at the state level to the list of controlled substances, it can sometimes affect which drugs an employer can test for. In those states where they don't delineate which drugs, they simply sort of, punt on the issue and defer to this, sort of long list of controlled substances that the state maintains. So we track those ones as well as DUI because of the marijuana situation nowadays, and whether or not individuals who get pulled over for reckless driving, let's say, can be cited for driving under the influence of marijuana. So we're tracking those ones. That's not something we've tracked in the past on a regular basis. We do now. Let me jump into some examples. We're not going to be able to touch on every single bill that got passed this year, but let's look at a few examples, some that are sort of very out there and have been somewhat controversial in some cases. As some of you know, for a number of years now, there have been states passing, we'll call them welfare-related drug testing laws. That's individuals who are applying for some type of housing assistance, food stamps, some type of welfare assistance. Now, there's a program typically in most states called Temporary Assistance for Needy Families, TANF, and in Alabama, a law was passed. It requires the Department of Human Resources in Alabama to implement and administer a drug testing program for people who are applying for TANF cash benefits. And it's pertaining to reasonable suspicion. So upon reasonable suspicion of illegal substance use, and that's the term they use, that individual may be required to submit to a drug test. The cost of the testing is the responsibility of the Department of Human Resources. It could be on subsequent tests of an individual who's been screened and test positive. Additional tests may be the cost of the individual if they want to remain in the program. And then look at that fourth bullet down. Adults that test positive, are late for their test, or refuse to be tested will be considered ineligible for their temporary cash assistance. So this is important. Now, there have been legal challenges to these types of drug testing laws, and lots of times when the law will separate the cash benefits that a child can qualify for versus an adult, or sometimes when these laws are tied to some type of an employment-related issue, which we're going to see in another example coming up, they'll usually survive any kind of legal challenges. We'll see what happens here with the Alabama SB 63. Delaware, different situation. This is more of a workplace drug testing law that was passed. It requires the justice of the peace court to conduct drug testing of any employee or applicant for a uniform service position, and this includes individuals who will be carrying a firearm. It requires pre-employment testing, random testing, and reasonable suspicion testing, and as you see in that third bullet, it's sort of the normal SAMHSA 5 drugs there. Individuals who test positive can either be terminated, suspended, they can be referred for treatment, but an employee cannot be disciplined for testing positive for a substance that they had a legal, lawfully obtained prescription and they were using it the proper way. Now, this is important because if you're doing business in Delaware as a drug testing provider, you may want to look into, the potential opportunities that exist according, that have been created by this law, according to this law. You need to know up front that lots of times criminal justice related testing, and this is somewhat criminal justice, it's employees of the criminal justice system. Those can be very sort of low margin, very competitive type of contracts that go out to bid, and they usually have very specific requirements. But it is an area that some drug testing providers really focus on. They specialize in working with public entities, with criminal justice agencies, and sometimes criminal justice testing of parolees and things of that nature. So this is a development in the state of Delaware. In Illinois, it's another workplace drug testing law relating to Department of Correction employees. And it's an amendment to an existing law, and it changes the requirement for education and ongoing education for employees who actually administer the collection of a sample. So it used to be a 40-hour initial training. Now it's a 15-hour initial training that's required with 8 hours of follow-up training that has to take place. I think it's annually. But otherwise, the rest of the Illinois law pertaining to drug testing of Department of Corrections employees remains unchanged. If you're there in Illinois and you're dealing with Department of Corrections and you have them as a client, this is something to be aware of, especially if you're obviously in the business of providing that training. Now, Georgia passed another welfare-related drug testing law. This is for applicants and recipients, so existing recipients, of food stamps or temporary assistance for needy family benefits. And this, again, is another reasonable suspicion of drug use program that would trigger drug testing. I've underlined the second bullet. Let me read it to you. Reasonable suspicion may be based upon demeanor, missed appointments, arrest or other police records, employment or application in an industry that requires drug testing. That's an interesting add-on there. Employment or application in an industry. Employment in an industry that requires drug testing, as well as application for a position or a job in an industry that requires drug testing, as well as termination from previous employment related to substance abuse. So all of those things may be considered reasonable suspicion. If you're providing this type of drug testing or you're working with the state on something like this, you need to know that. You'll probably be required to do training in this area. The type of testing that gets conducted has to be in accordance with the mandatory guidelines of the Federal Workplace Drug Testing Program. This is Part 40 type of stuff here. And so, well, it doesn't say DOT and it doesn't say Part 40. Those are the, those mandatory guidelines are where you're going to find, sort of the procedural requirements for this new law in Georgia. Except, there's a big except here, which is the law specifically states that when possible and practicable, an oral fluid swab test will be used in lieu of urinalysis. That, of course, is a departure from existing federal guidelines, which right now only touch on laboratory-based urine testing. Well, I think we all know, right, that SAMHSA is in the process of developing regulations for lab-based oral fluid drug testing. We're probably still a year, maybe 2 years out from seeing something on that, something final and definitive. But we already see the acceptance of oral fluid testing encroaching in areas that have traditionally been the domain of lab-based urine testing. And here's another example of that. You can see that in that second to last bullet, there's a lot of different things that are actually covered. I just sort of captured it all in one bullet there. But the cost of testing is the responsibility of the person being tested. The first one we looked at was the responsibility first of the Department of Human Resources, remember, and then subsequent testing, the responsibility of the individual. Here in Georgia, it is the responsibility of the individual being tested. Georgia's very interesting. Georgia's very progressive when it comes to drug testing. They have a workers' comp premium discount law. It's voluntary law, but for employers in the state of Georgia that can qualify to get into that program and qualify for a discount in their workers' comp premiums, they may do so. There are other states like that, but in Georgia, they are different in the sense that when they passed the law, it was really only a urine drug testing program, and they later passed the law to include oral. Very interesting and very progressive, maybe a model for other states to follow. Now, Mississippi, excuse me, is another TANF or TANF benefits drug testing program. But in Mississippi, it's a little bit different because it includes a questionnaire the individual would fill out, which is designed to sort of determine the likelihood of the applicant having a substance abuse disorder. I have not seen that questionnaire. I don't know that it exists yet, but it is unique to Mississippi versus some other states that have these temporary assistance for needy family testing type laws. The definition of a drug includes testing person's bodily fluids. And so this, and it's specific bodily fluids, so this would include urine and oral fluid, but perhaps and most likely exclude hair testing because that's not technically a bodily fluid. Okay, and there's some other points there as you see. Second to last bullet, this requires the Department of Human Services in Mississippi to pay for the drug testing. So the Department of Human Services in Mississippi is technically the client for this type of drug testing. And that may change significantly how a provider provides that service and how they get paid, and probably what they get paid, how much they get paid, okay? In New Hampshire, there is a new law that requires licensed healthcare facilities and providers to establish a drug-free workplace that includes at least reasonable suspicion testing. Now, as you can see in the third bullet, there are a lot of other things, okay? It must include employee education, monitoring of inventory of controlled substances are administered at the facility, voluntary self-referral, an employee assistance program of some sort, et cetera, et cetera. Important because a lot of states, not just New Hampshire, but other states as well, have drug testing laws that affect healthcare facilities and providers of healthcare services. Other states have drug testing that's specific to elderly care, home health care workers, et cetera. This is a growing area of the drug testing industry. There are not a lot of drug testing providers that are active in these particular markets, but these are growing areas of opportunity in the drug testing industry. And so if you're a drug testing provider in New Hampshire, as well as a number of other states, there are laws that mandate, in some cases, drug testing of healthcare workers, and that also provide very, very detailed requirements for that type of drug testing. Obviously important to know if you're in that business, but also important to know that these markets exist. So, you know, we're talking a little bit like the early days, 25 years ago, when the DOT regulations were coming into existence and what were employers going to be required to do, et cetera. That really, you know, was not the beginning of the drug-free workplace industry, if I can use that term, but it was certainly, you know, when the drug testing really started taking off on a wide-scale basis. Now we do the survey every year. One of the questions we ask typically, not every year, but maybe every other year, is as we interview drug testing providers, is what percentage of your drug testing business today is DOT versus non-DOT? Well, 20 years ago, 17 years ago, actually, when we started doing this survey, but you know, 20, 25 years ago, the vast majority of drug testing in the workplace among most companies, or providers, excuse me, was DOT-mandated drug testing. We built our industry on DOT-mandated drug testing. However, for some years now, and borne out again in our 2013, 2014 surveys, the vast majority of drug tests today are non-DOT. DOT-mandated drug testing make up about 20 to 25% of all drug tests, according to our survey. Well, in a particular company, as you look at this New Hampshire laws, you look at some of these welfare-related drug testing laws, you may have a higher percentage than other providers because you specialize in drug testing in the healthcare industry. Again, as I said, not a lot of providers traditionally or typically are strong in this area, but I think it represents opportunities that are certainly worth exploring. Now, I did mention that one state tinkered with their workers' compensation law in 2014. That was Arizona. There may have been others. This is the one we decided to focus on. This one is interesting because it puts the onus on the physicians who are providing some type of managed care or workers' compensation treatment and care to an injured worker. And so this bill, which was passed, requires physicians to include a description of what they're doing, the measures that will be taken to prevent the abuse, the dependence, addiction, or diversion by patients being prescribed controlled substances. So they're accountable to the Industrial Commission of Arizona to make sure there's a plan in place in how they administer controlled substances to ensure that the patients don't become addicted to these drugs. The physician has to include a random drug testing component in the medical treatment of these patients. So that's an interesting thing. And then that third line there, if the individual procedures, or if an individual produces inconsistent drug test results, physicians must provide a written report to the insurance carrier, the self-insured employee, or an Industrial Commission of Arizona within 5 days, setting forth the treatment plan for that individual whose inconsistent drug test results, meaning they've been testing positive and to, beyond what you would expect on somebody using these controlled substances as part of a treatment program. And so a lot of responsibility falling on the shoulders of physicians to carry out this type of drug diversion, drug testing, random testing, and it may create opportunities for people in the drug testing industry, possibly. So we included it there. It's certainly an interesting development. Now, I mentioned that there are a number of states, as you can see in that first bullet, there's a list of 5 states there that all passed bills affecting the definition of or the inclusion of some substances in their list or their definition of controlled substances. I'm pulling out just one example, Minnesota, and that is a cease and desist authority to the pharmacy board in Minnesota to order to prevent the sale of synthetic drugs. And there are lots of different kinds of synthetic drugs, of course, but some of the more well-known ones have typically been in the press, for many years now. Identified as a problem, let's say, in Minnesota, so much so that this bill was passed granting specific authority to the pharmacy board to address the issue. It could be, we see more of this in other states going forward. It was the only one I noticed for 2014, but thought it was worth mentioning. Other states did pass laws as well. Now, just in a final note on these state drug testing bills, and then we're going to get into the marijuana issues. When Colorado legalized marijuana back in 2012, they did not have a section in the bill that the voters voted on to define what a DUI would be for THC, a driving under the influence. So somebody's pulled over for reckless driving, let's say, and the law enforcement official conducts a test or some type of, say, oral fluid sample is taken, and, what would be considered, driving under the influence in some way equivalent to blood alcohol content for an alcohol screen. Well, there wasn't anything in the Colorado law. They since have passed that. It's very similar to Washington, which also passed the recreational marijuana law in 2012, which establishes 5 nanograms per milliliter as the sort of the equivalent of a BAC .08. So we're now seeing that 5 nanograms per milliliter sort of being established. It's not a nationwide thing by any means at this point. We might see something like that. But Maine tinkered with their DUI law. It amends the operating under the influence part of that law. Michigan also did something similar, and specific to controlled substances. We're seeing states getting more specific about those things, especially states that have passed medical marijuana laws, or in the case of Colorado and Oregon prior to this year, that have legalized marijuana for recreational use. Alaska, Oregon, the District of Columbia also follows suit in terms of legalizing marijuana. But we're seeing more states, again, those with medical marijuana laws, as well as other states, starting to sort of take some proactive measures to establish a DUI level consistent throughout that particular state, related to THC in particular. Okay, so that sort of takes us through the various sort of non-marijuana specific laws or bills that were passed in 2014. We're about to launch into the marijuana laws. Let me just say, if anybody has any questions about any of these bills, or anything related to any of this, this is our last general webinar for the year. So please submit your questions. If we don't have the information, if I'm not sure what the answer is, we can look it up for you and send that information to you in an email or give us a call. We'd be happy to try to look it up while we're on the phone together. Now we're going to take a little time to talk about marijuana legislation passed in 2014. It's been a very active year. Now, these next couple of slides list a lot of different states, some of which you probably did not hear about in the news because it wasn't necessarily the passing of a new medical marijuana law or the legalizing of marijuana in general, but they've done a little bit with their marijuana laws in general. There are lots of laws pertaining to marijuana on a state-by-state basis, and most of it, a lot of it, I should say, is sort of governed at the state level. What would be considered illegal possession, or what might happen with, transferring drugs within the state, what type of penalties may exist in one state versus another state when it comes to possession or use or transferring marijuana to another person. So this slide and the next slide kind of deal with that a little bit. I'm not going to say a lot about these two slides except to just point out the fact that, like New York, you see there at the bottom, legalized medical marijuana. Well, another state like Maryland at the top altered an existing medical marijuana law. They're constantly tinkering with that. And as I get into some of the case law that's developed, I'm going to talk about this tinkering process. But first, we're going to talk about the big ones that passed in 2014, Alaska, Oregon, and the District of Columbia. All three of these jurisdictions voted to legalize marijuana, and it was the will of the people speaking. So following the example of Colorado and Washington, Alaska, Oregon, and the District of Columbia have legalized marijuana. Just like in those states, there's some limitations that apply, but they each take kind of an interesting, unique look at this whole issue. And while they've legalized marijuana in all 5 of these places, they haven't legalized it exactly the same as any of the other places. So we'll talk about some of the differences here. Alaska, the bill that voters in Alaska voted on back in the midterm elections in November was very similar to the Colorado law. Now, Colorado had a few unique things about it, okay, and some of which was picked up with the Alaska law. There is very generic language in the Alaska law, as you see there in the last bullet, on the workplace. Nothing in this chapter is intended to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growing of marijuana in the workplace, so that's very limiting, right? Or to affect the ability of employers to have policies restricting the use of marijuana by employees. That's much broader, okay? Just like in some of the other states that have passed medical marijuana laws, and incidentally, Alaska and Oregon and the District of Columbia already had medical marijuana laws on the books, as did Colorado and Washington back in 2012. But we'll see challenges to the wording that relates to the workplace. This is not a done issue. It's just the beginning of the issue as the pro-marijuana people use language that they think they can get passed, that they can convince voters to approve, but then they start tinkering with it, either through the legal process or through the legislative process, and there's a number of examples of that. In Oregon, the Oregon law is a little bit different than the other 3 states and the district that have legalized marijuana. There's this tiny little bit of language in there, as you see at the very bottom, related to the workplace, basically says that the act may not be construed to amend or affect in any way any state or federal law pertaining to employment matters. Very, very broad, very, very loose, very, very subject to legal challenge. Look under possession, though. This is unique to Oregon. Any person 21 or older, that's the same everywhere else, whether they're a resident of Oregon or not, that's a little bit unique, can possess up to 1 ounce of pot on their person. 1 ounce of pot comes out to generally 28 joints. So you can be walking down the street with 28 joints on you, and law enforcement will do nothing. Now, I would wager almost any amount of money that you could have 46 joints on you in Oregon, and nobody's going to do anything to you, okay? But you can have up to 28 joints on your person and up to 8 ounces in your home, as well as up to 4 plants. So somebody with 8 ounces of marijuana, that's about 200 joints thereabouts. That's a lot of marijuana to have at your home. And, you just grab a handful, 28 of those joints, you can take with you wherever you go. It goes on to say, and this is something that was really sort of one of the unintended consequences of the laws that were passed in Colorado and Washington early on, which is this whole issue of edibles that have been laced with, infused with marijuana. The law allows a person to possess up to 1 pound of solid edibles, like cookies, we see a lot of that, cookies and brownies, etc., up to 72 ounces of marijuana-infused liquid, like soda or lotion, and up to 1 ounce of marijuana extract. Well, again, that's a lot of marijuana. I mean, to have a pound of cookies, it's Christmas time, of course, and we're all eating more sweets probably, and certainly over the next couple of weeks we definitely will be. But that's still a lot of, that's a lot of cookies to have a pound of solid edibles like cookies that have marijuana in them. And of course, part of the challenge that they've faced in Colorado is that there are no standards. There's no FDA approval process for these marijuana edibles. And so, you might buy a cookie, a single cookie that's singularly wrapped, that has instructions on it saying only take 1 bite per hour of this cookie over 8 hours. But who eats a cookie that way? Nobody. And so, you're eating enough in every single bite to sort of get the buzz from marijuana, except you're going to take 8 bites of a cookie. You're going to consume the entire cookie. You're going to have 8 times the amount of THC in your system that you would from smoking just 1 joint, a typical joint. And so, unfortunately, one of the unintended consequences has been people doing some incredibly dangerous and even deadly things while under the influence of a marijuana cookie. One person, and this, from Colorado, this was well documented in the media, but jumping out of he was on the 4th floor of his hotel room, jumped to his death after eating a marijuana cookie. Another man, after eating a marijuana cookie, took out a gun and killed his wife. He shot his wife well under the influence of an entire marijuana cookie. And so these are tragic things, and there's no oversight for these edibles. And so in Oregon, at least, they've tried to create some oversight here, but still it's very, very loose. 1 pound of solid edibles like cookies, that really means nothing, okay? But give them credit for at least putting it in their law because they saw what was going on in Oregon or in Colorado and Washington. The District of Columbia did something completely different, okay? During the midterm elections, D.C. voters went to the polls and overwhelmingly approved an initiative that legalizes marijuana in the District of Columbia. You can possess it and you can cultivate it if you're 21 or older, okay? It does nothing to affect the federal law, which still considers marijuana illegal, right, under the Controlled Substances Act. But it's now legal, or quote-unquote legal, in the District of Columbia. It's subject to congressional approval. I'm going to come back to that in just a few seconds. But what's interesting is that it did not create a legal marketplace for marijuana. Colorado, Washington, Oregon, Alaska, all created legal marketplaces for marijuana, meaning there can be growers who legally produce marijuana. There can be wholesalers who buy the product, transfer it to retail outlets, and there can be retailers. And every step of that process is taxed, and the tax dollars are collected by the state, and they go towards various things. Well, in D.C., they didn't do that. They just simply legalized it. And so you can use marijuana in Washington, D.C., but you can't actually sell it in Washington, D.C. legally. Now, I said it was subject to congressional approval. It is. It is subject to congressional approval. And over the weekend, last week and over the weekend, excuse me, all over the news, right, this $1.1 trillion budget was passed, and somebody attached what's called a rider to the federal budget that essentially undoes the will of the voters in Washington, D.C., and makes marijuana use in D.C. still illegal. Now, I was just reading up on it this morning, and there are already challenges in place to that, but that's essentially what happened. And so the D.C. people are trying to claim that, hey, we've got the authority to do this, but the District of Columbia functions under the authority of the U.S. Congress. And so we'll see what happens with that law, okay? It did contain a workplace section provision in the D.C. law that voters approved. It's very generic. It doesn't really say much to really hurt or more so to help employers. But we'll see what happens with that. There's something else coming up with the District of Columbia in my presentation that I'm going to share with you in a minute that's also very unique to D.C. Now, there were a number of states that passed medical marijuana laws in 2014. New Hampshire was one of them. I'm going to go through each of them, but I'm only going to talk about how they affect the workplace. So if you've got questions on a broader scale, you'll need to just email me or send them to me. This is interesting. In New Hampshire, this is unique to New Hampshire, okay? Nothing in this chapter shall exempt any person from arrest or prosecution for A, being under the influence of cannabis, while 2, in his or her place of employment without the written permission of the employer. That's interesting, isn't it? You won't find that, I don't believe you'll find that language in any other medical marijuana law. But essentially, as an employer, if you're stupid enough to put in writing that you've granted this employee over here permission to be at work under the influence of marijuana, then you probably deserve to be sued and to maybe even lose your business, unfortunately, because your drug-free workplace program and your drug testing program are intended to protect you in the event that an employee violates the policy and is at work under the influence and does something tragic, hurts or, heaven forbid, kills a person, causes tremendous property damage, etc. And yet it's possible in New Hampshire that an employer could put in writing that the individual has permission to be at work under the influence of cannabis. I think that's pretty stupid. That's maybe just my opinion. I don't know if I'm in the majority or minority on that one, but that's unique to New Hampshire. The law goes on to say that nothing in this chapter shall be construed to require any accommodation of the therapeutic use of cannabis on the property or premises of any place of employment. It goes on to say this chapter shall in no way limit an employer's ability to discipline an employee for ingesting cannabis in the workplace or for working while under the influence of cannabis. This is important language right here, folks, because we want to stay away from any argument pertaining to impairment. We don't want to use the word impaired or impairment in our drug testing policies because the courts have long ago ruled that a drug test doesn't really prove impairment. But you as an employer can define, in most cases, there are some states that take this away from you and they define it for you, but in most cases, you as an employer or your clients can define what under the influence is in this company. And among other things, you can include that under the influence means testing positive for marijuana. Well, if you take that approach, you significantly sort of reduce the wiggle room that an attorney would have trying to sue you for terminating the employment of somebody who was at work who tested positive for marijuana. It's not foolproof by any means, and I'm not a lawyer. I'm not telling you to do it that way, but you have to be careful in which words you use, impairment versus under the influence. They can be, and they typically are, two very different things. New Hampshire uses the term under the influence in its medical marijuana law. Some of the other states use the word impairment. Illinois is unique because it includes language about drug testing. Nothing in this act, the medical marijuana law passed in Illinois in 2014, shall prohibit an employer from enforcing a policy concerning drug testing, zero tolerance, or a drug-free workplace provided the policy is applied in a non-discriminatory manner. Hopefully, we're all applying our drug testing programs in a non-discriminatory manner. Of course we would do that. We don't want to discriminate necessarily against medical marijuana users. We just want to be able to hold them to the same standard of productivity, attendance, safety, etc., as all other workers in the workplace on our payroll. And one of the ways that we're doing that is by establishing drug-free workplace programs, drug testing for marijuana, etc. Illinois goes on to say, though, nothing in this act shall limit an employer from disciplining a registered qualifying patient from violating a workplace drug policy. Boom. I should underline the word drug policy because, as always, and this is our core business, writing drug testing policies, as always, it comes back to that policy. And I don't have a dedicated section in this presentation today on the policy, but let me just say here that in today's world, in the United States, every drug-free workplace policy should have a dedicated section on the subject of marijuana, even if you're not in a state with a medical marijuana law. You need to have something in your policy that is dedicated to addressing this issue. Otherwise, you're potentially asking for trouble, especially if you're in a state that has legalized marijuana. In Illinois, as you see, it refers directly to your policy, and that policy needs to be in writing, and it needs to cover cannabis or marijuana. Minnesota is different. Minnesota new medical marijuana law does not allow the smoking of marijuana. So that's unique because an individual who smokes a joint in the parking lot on their lunch break and then comes back in and tests positive with an oral fluid test, that can capture that use immediately after the person's used the drug, they're going to test positive with an oral fluid test. The individual can't claim protection under the medical marijuana law in Minnesota because it doesn't cover smoking marijuana. It does have some general language in the Minnesota law on employment, as you see there in the second bullet. But here's the real kicker for marijuana. A person being a registered medical marijuana patient, I'm skipping around. Number 2, a patient's positive drug test for cannabis components or metabolites, unless the patient used, possessed, or was impaired by medical cannabis on the premises of the place of employment or during the working hours, cannot be, the employer cannot discriminate against that individual in hiring, termination, or any other term or condition of employment. You cannot penalize that individual for testing positive for marijuana simply because they're a medical marijuana user or registered medical marijuana patient. So the individual has to have proof of their registration, but you can't discriminate. You can't terminate simply based on that. That's very similar to the new medical marijuana law in New York, also, although New York takes it to an extreme beyond Minnesota. But as I said for Minnesota, it doesn't allow smoking of marijuana. Same in New York. Now, New York goes a little bit out on the limb on this a little bit, okay? Employers are prohibited from taking disciplinary action against an employee simply because of their lawful use of marijuana. That term lawful use is really going to come back to either make or break the drug-free workplace argument against marijuana. As we're going to talk about in Colorado in a minute, it's all based on the Lawful Activities Act that exists in some of these states. And when you legalize marijuana for medicinal purposes, essentially for registered users, they're now lawfully using marijuana. And some laws come into play that are not even related to a drug-free workplace or a drug testing program, but will in the future. Now, the second bullet's important. Employees lawfully using medical marijuana are considered to have a disability under the New York Human Rights Law. Very different than the ADA, right, which does not consider current drug use, illegal drug use, or illicit drug use to be a protected activity or to be a protected class of individuals under the Americans with Disabilities Act. But look at that third bullet. Employers are required to consider making workplace accommodations for employees who lawfully use medical marijuana. Well, what's that mean? Well, it can mean a lot of different things, right? But in New York, let me find the bullet here. Let's start at the top. Employers may enforce policies and procedures prohibiting employees from performing their job duties while impaired by controlled substance. Unfortunately, they use the word impaired in the New York law. Second bullet, though, employers are not required to allow employees to utilize or carry medical marijuana if it would violate federal law, and it is against federal law, or put their business in jeopardy of losing a federal contract or federal funding for their particular company. Well, that's important to know. That's very important language, and that's something that we will probably see the pro-marijuana people challenge in the very near future, because as it exists right now, federal law considers marijuana illegal. And in New York, right or wrong, they made the mistake of including that language in their medical marijuana law as it pertains to the workplace. But furthermore, individuals are strictly prohibited. These registered medical marijuana law, users are prohibited from smoking medical marijuana. So again, just like in Minnesota, if an individual is out there smoking a joint on their lunch break and they come back, they test positive on an oral fluid test right there on the spot, they can't claim protection under the medical marijuana law because it doesn't allow smoking for marijuana. It disqualifies them from any protections that exist in the law. Something unique about Minnesota and New York. Now, I said there were some court cases. In Colorado, Coates v. Dish Network, the case in which an individual, Mr. Coates, was terminated from his employment with Dish Network. This goes back a number of years, before they had the recreational marijuana law, but after they passed medical marijuana. He was terminated. He was a registered medical marijuana user. He tested positive. He was terminated. He sued to get his job back. He lost in court because the judge ruled that in order for him to successfully challenge his termination, the state law and the federal law had to be consistent. They couldn't be contrary to one another. And of course, in this case, in the whole case of medical marijuana, it is a conflict. All of these legal state laws are in conflict with the federal law. The judge ruled in favor of Dish Network. Well, Mr. Coates and his attorneys are now challenging this at the Colorado Supreme Court level. They've heard the case. I just checked. I haven't seen anything in terms of a final ruling. But basically, they've made their argument on the lawful activities law of the state of Colorado. That law prevents an employer from indiscriminately, terminating, let's say, an employee solely based on their activity in their participation in a lawful activity. In this case, using marijuana, which is a lawful activity in the state of Colorado. Well, we're going to see what happens with that, but it could have ramifications throughout the entire country. And it won't just apply to marijuana, which will be a significant setback for employers, but it will also pertain to other types of testing, or prohibitions that employers typically have. You might be in a workplace that doesn't allow smoking, or you might work for an employer who does cotinine screens before hiring somebody, nicotine testing. Well, smoking is a lawful activity. It may not be lawful in certain places, but generally it's a lawful activity. These lawful activities law challenges, the one that we see in Colorado being the most extreme right now, could have an impact on a lot of things that employers do from a policy standpoint. Michigan's unique because Michigan has a medical marijuana law, and there's been one major challenge to it that went in favor of the employer, Walmart, in the state of Michigan. But now we see from this Nebraska versus Challenge Manufacturing Company that testing positive for marijuana will not in and of itself be appropriate means for denial of unemployment compensation. That's a significant development, and that could have far-reaching effects in other states as well. Now, these are the states that Ethan Nadelmann, the executive director of the Drug Policy Alliance, he's been at this for a long, long time. He's really made it his life's work to try to get illegal drugs legalized in our country, marijuana as well as other drugs, if I understand correctly. I debated Mr. Nadelmann many, many years ago. He probably doesn't remember me, but I remember him. And he is projecting that California, Maine, and Nevada are very likely to legalize marijuana generally for what's called recreational use in 2015. And Massachusetts and Arizona are also possibly going to legalize marijuana in 2015. If I said 2014 earlier, I meant 2015. That's something we've got to watch out for, okay? But they're all in green on your screen here because all 5 of those states already have medical marijuana laws on the books, California being the first state to legalize marijuana for medicinal purposes. Now, got a few slides on our 2014 drug testing industry survey, and then I'll entertain any questions that you have. But I'll go through these quickly. You're welcome to all of these slides. We'll include a link to where you can get these slides if you would like them, if you have attended today's webinar. We survey drug testing providers. And we always ask about trends in certain areas of drug testing. We ask lots of different questions. We have an entire section on brand name recognition, which I will not have time to go into today. But if you're interested, we'd be happy to share the entire survey results with you. Oral fluid testing. What percentage of all drug tests are oral fluid tests? We asked that question. 25% said 5% or less. Almost 30% said between 5 and 10%. And then it diminishes after that. So the majority of providers think it's somewhere between 1 and 10%. That's, almost what would come about 55% there. That's pretty significant. But also, if you look at the bottom there, 24%, 23.9 said they really don't know. So still a lot of providers not really sure about oral fluid testing. Maybe they don't even provide it themselves. Almost 13% said sales are up considerably, and 24.2% said oral fluid sales in 2014 compared to 2013 were up at least modestly. 22.8% saying the same, said sales were the same. So if you add those first three categories, you see that oral fluid tests are pretty solid right now. I mean, you're either the same or you're seeing a modest to considerable increase in sales. So heading in the right direction, a lot of that based on the projection that SAMHSA will come out with lab-based oral fluid regulations sometime in the next year or two. Hair testing, again, very similar. We see bigger percentages between the 5% or less, and then the second line between 5 and 10%. That's over 65%, 66% actually. Only 15.4% saying they did not know. Sales, however, 5.6% up considerably, 35.2% up modestly, and 23.9% saying that they're about the same. Again, hair testing, pretty solid. If you like it, you like it. If you don't, you don't. Sales are going up, at least modestly, among most employers or most drug testing providers. Point of collection tests, POCT, on-site, rapid result, etc. Now you see sort of a flip of those percentages compared to hair testing and oral fluid testing, where more, 33.8%, say that it represents more than 20% of all drug tests. 21.1% saying between 15 and 20%. Only 4.2% saying less than 5%, and 18.3% saying they don't know. Point of collection has been around longer. It's got a following. It's certainly popular in certain industries. Again, the majority indicating that sales are up considerably, modestly, or about the same. But 29.5% said they do not sell POCT devices. That's an interesting development there. Predictions, I'll let you go through these as we're running out of time here, but most people predicting alternative testing such as oral fluid and hair will continue to grow in popularity, oral fluid testing in particular because of the pending regulations coming out of the Drug Testing Advisory Board and SAMHSA. Some people predicting that 2014 has been a year of busy acquisitions and mergers. 2015, a prediction that if you're in that $3 to $5 million category, you're about to be acquired. I don't know if you knew that or not, but that was one of the predictions. Continued demand for one-stop shopping for employment screening. We've seen that trend over the years. Buy your drug test here, buy your background screening test at the same place. Get all of the services from one provider. We'll continue to see that, I think, undoubtedly going forward. I think we'll also see as that second bullet, this is a big trend, using multiple testing devices or methods in the same drug testing program. Employers who maybe do hair testing for pre-employment and oral fluid testing for reasonable suspicion and post-accident, sort of mixing it up to get the best of both worlds. Maybe they do urine testing to comply with the DOT regulations, but under their own corporate authority, they use hair testing for pre-employment screening. We see a lot of that in the trucking industry. Predictions going forward, I think a lot of people are really concerned about the legalization issue. I just captured in one bullet on this page, the last one, but it was really the topic that dominated the discussion in terms of concerns and predictions. And we even asked specifically about that issue. We included that question, interestingly enough, in our international survey as well. And we found that in most countries represented in the international survey, there was very little or no concern at all about the legalization of marijuana. They said in their country, there's no appetite for it. Their biggest concern was whether or not this movement in the United States to legalize marijuana would make its way across the ocean or south of the border, so to speak, and start to infiltrate in their countries where they do business. But they don't see an appetite for it in the countries that were represented in that international survey. This is very interesting. This is our last slide here, the legalization of marijuana. I just want to point you right to the smack dab to the middle there. We asked the question whether you agree or don't agree with this statement. Employers are confused and worried about how to deal with marijuana in the workplace. 67.6% of drug testing providers agreed with that statement, and 16.9% said some employers have already eliminated marijuana from their drug test panel. So this is a big concern. It has a big impact on the drug testing industry, and the people on this webinar today, mostly drug testing providers, have a unique responsibility to educate your clients, on the reality of this situation and the fact that they've got to deal with it. There's just, you've got to deal with it as a provider, and they have to deal with it in their drug testing policy because it's not going away anytime soon. The projections on the pro-marijuana side are for more successes in 2015, but employers still have the right to drug test for marijuana. They still have the right to hold employees responsible for testing positive and being at work while under the influence of marijuana. So it's something that they have to address in their policy. And you as a provider, we as an industry, I think have the main responsibility to provide education to the workplace, to employers on this topic. Now I've got just a couple of minutes left. Let me get to some of these questions, but let me say also, if you have questions I don't get to today, because we are just about out of time, please email me. I'd be happy to, help out any way that I can. We will incidentally be doing monthly webinar series again in 2015, hosted by and sponsored by OraSure Technologies. Want to again thank them for their efforts to provide educational information to the industry, and we'll be kicking that off. I think it's the third Tuesday in January. But if you're on today's webinar, you'll receive notification of future webinars as well. We have a question here. It looks like I've got time for at least one. For those states that have either legalized recreational marijuana or who are on deck to legalize marijuana, have they all first legalized medical marijuana? Right now, the answer to that question is yes. And let me explain why that is the case. If you go back in life a little bit like I do, back to the 70s when I was going through high school and when I went through my young adult years, you know that there was a big push on in the 70s to legalize drugs, period, and marijuana in particular. Well, there was really no appetite for it throughout the country to legalize marijuana. So I think the marijuana people made a strategic decision to shift their focus from legalizing marijuana generally to legalizing it for medical purposes. And so that compassionate, that argument for the compassion of your fellow man became sort of the strategic, core of the pro-marijuana movement. And it's hard to argue against that. If smoking marijuana helps alleviate the extreme pain or suffering that a cancer user is going through, then it's hard to argue against that. I understand that, okay? Even as somebody who's against legalization, I understand that argument. But that was never really their intent. Their intent has always been to legalize marijuana. I didn't include it in today's presentation because it was more about, laws in general. But if you go to the Marijuana Policy Project website, marijuanapolicyproject.com is what I think it is, but the Marijuana Policy Project, you'll find their mission statement and their goals on there. And their goal is to put so much pressure on Congress to legalize marijuana by passing state-level legalized marijuana laws that by 2019, in just 3-4 years from now, their goal is for marijuana to be legal under federal law, remove it from Schedule I, put it somewhere else, and legalize marijuana generally. So their whole game is, the end game for them, their intent was never to legalize it just for medical marijuana purposes, for medical use. It's always been for general use, and so now we see that happening. And so all of the states so far, Colorado, Washington, Oregon, Alaska, and the District of Columbia, all had medical marijuana laws on the books before voters were given the opportunity to vote to legalize marijuana for recreational use. And the 5 states that Ethan Nadelman are projecting will legalize marijuana in 2015, all 5 of those states already have medical marijuana laws on the books. So the answer to your question is absolutely yes, and we're going to continue to see a lot more of that. I see that I'm out of time. I don't want to go over because I know your time is important and you all have things to get back to. But any questions I didn't get to, I will respond to. If you have any questions you didn't ask and you want to ask, please email me. You see one of my email addresses there, bcurrent@currentconsultinggroup.com. And with that, I'm going to turn it back over to Jessica, who will explain how you can listen to today's presentation again and get today's slides.
On behalf of OraSure Technologies, we hope that you have found today's presentation informative and helpful. This presentation was recorded and you will receive instructions informing you how to access the recording. Thank you for your attendance today. This concludes today's webinar.